Good afternoon, everybody. A warm welcome to all for this online webinar on intellectual property rights. So it is organized by Chairman Hanuman Institute of Pharmaceutical Sciences in association with the Ministry of Education, AICT New Delhi, and Institution Innovation Council. On this occasion, I cordially invite the guest of this today's session, Mr. Ashish Sharma Garu. Sir, good afternoon, sir.
Sir, very good afternoon. Very good afternoon.
Good afternoon, sir. This is Dr. Shezar from Chairman Hanuman Institute of Pharmaceutical Sciences, sir.
Very good afternoon, sir.
Very good afternoon, sir. So
sir, good afternoon, sir.
Yes, very good afternoon, sir. See
Namaste,
you.
sir. Welcome.
Yeah. Very nice to see you, sir.
Yeah.
So now I request one of my colleague, Dr. P. Pawan Kumar Garu, so to introduce the guest of this today's session, Mr. Ashish Sharma ji.
Very good afternoon, sir. So on his expertise in intellectual property rights today, I would like to invite Advocate Ashish Sharma ji for the current session. He is managing partner of IP Nation, the law firm, registered patent agent and IP facilitator for startups, Government of India. He is IP attorney, global IPR law consultant for India, and he is Secretary General IP Owners Association India. He got 15 years of vast experience in intellectual property rights. He is registered patent agent and IP facilitator for startups. He is Secretary General of Intellectual Property Owners Association. Along with, he also has a vast experience in research and development in pharmaceutical sciences. He also helped in getting number of patents in pharmaceutical and biotechnological fields. He look after the drafting and prosecutions of patents, designs, trademarks, and copyrights matters. He is well versed in US, European, and Indian intellectual property laws. He also appeared in number of cases before Controller of Patents, before Intellectual Property Appellate Court, and before Indian courts also. His major responsibility includes coordination with all nation and international clients. He also handling licensing, IP, enforcement assignments, contracts, and litigation matters pertaining to various sectors. He also regular invitee as guest lecturer and speaker on IP related subjects in various organizations, reputed organizations, various universities, including law schools, management schools, R&D institutions, corporate academics, university departments, etc. So today, Advocate Ashish Sharma going to share his clear views on IPR to our participants. You can continue, sir.
Thank you, Dr. Pawan, and thank you all the management staff who has organized this session pertaining to intellectual property rights. So basically, intellectual property rights are the intangible rights which is created by mind. So you can say the IP rights are creation of mind. Here I would like to share a screen. So should I?
Sure, sir. Go ahead, please.
Okay. Yes. So what is intellectual property right? Intellectual property is a property which is intrinsically intangible, developed due to the creation of mind. It can be an expression of an idea, or in the terms of invention, expressions of literary collection, unique name, trade name, industrial designs, these shape which as the appeals to the eye, new plant varieties, cinematographic, dramatic, performance, musical, story. So these are some of the type of intellectual property rights. So invention means which is new, which is novel. It should be novel throughout the world, across the world. because if your invention, if your work is already known anywhere in the world, so it will not go to the patent because it is already known in the public. So these are the types of intellectual properties: patent, trademark, copyright, designs, geographical indications, plant varieties, semiconductor designs, trade secrets. So here I would like to discuss in the more focus to the patents. So these are some Indian acts relating to IPR. The Patent Act 1970, it was last amended in 2005, and the Trademark Act, the Design Act 2000, geographical indications of goods, the Copyright Act, protection of plant varieties, the Semiconductor Integrated Circuit, and Biological Diversity Act. So here you can see, so basically sometime there is a confusion between patent, trademark, whether our work should be patent or trademark or copyright or geographical indications or designs. So here you can see what is protected under patent: invention. Invention can be protected under patent. And what can be protected under trademark? Words, phrase, logo used as a trademark on goods or service. Copyright, you can see original, literary, dramatic work, musical and artistic work, cinematography, film, sound recordings, literary, any film, movies, so which will come under copyright. Geographical indications means identification of goods pertaining to the geographical source of reason of origin, like Mysore silk. Mysore silk related to the Mysore, and Darjeeling tea related to the Darjeeling. So these are the types of geographical indications. Designs means shape, configuration, pattern, ornamental, applied to article and judged by the looks or appeals to the eye. So shape, configuration, patterns, ornamentals, these type of intellectual properties can be covered under design protection. So how to protect? File the application for a grant of patent in a patent office to protect the patent. File application for registration of trademark in trademark registry. File application for registration of copyright with the register of copyrights. File application for registration of geographical indication with the GI registry. And file application for registration of design for Indian Patent and Design Office. So who can apply the patent? Inventor or assignee, user or proprietor or owner. First, author or assignee can file the copyright, and geographical indications can be filed by only association of persons, not for any individual persons, but it should having more than 3, 4, 5 persons, and it should having an association of persons. Association of persons and designs, proprietor of new or original designs not previously published. So what are the tests for protection? Novelty, inventive concept, utility, distinctive use based. For a trademark means for a patent there is a criteria for a novelty, inventive step and utility. And for trademark, distinctiveness, used based, and for copyright, originality, source of geographical origin, and for a design, new and original. For a term, if you see the term of patent, the term of patent is 20 years from the date of filing. And for a trademark, 10 years initially and renewable indefinitely every 10 years. Copyright over 60 years after the death of the author, and geographical indications 10 years initially and renewable indefinitely. For a design protection, the term of design protection is 10 years initially and extendable by 5 years. So protection provided is a right to exclude other from making, using, selling, offering to sale, and importing for a patent. For a trademark, right to exclude other whose use may cause confusion or deception. For a copyright, right to prevent unauthorized copyright or public performance. For a geographical indications, exclusive right to the use of GI in the relation to those goods, and for a design powers to exclude others to use or apply registered design. So these are some organization structure of intellectual properties office. There are 4 patent offices in India: Delhi, Mumbai, Chennai, and Calcutta, and 5 trademark offices: Delhi, Mumbai, Chennai, Calcutta, and Ahmedabad. And the geographical indications is located in the headquarters located in Chennai, and design headquarters is located in the Calcutta, and trademark headquarters is located at Mumbai. So what is patent system? Now we come for a patent system. Patent gives the exclusive right to the patentee of the product process to prevent third parties who do not have his consent from making, using, offering for sale, selling, or importing for those purposes that product or the products produced by the patent process. So patent basically is a monopoly rights. So sometimes it may call the patent is the adverse view, the patent is the negative rights, which creates the monopoly, and monopoly kills the competition, and killing competition hampers the economic growth. So therefore, patent should not be granted sometime, but not. It is not, because a patent gives the motivation to the inventor. Patent is the right award for the inventor and reward for the investor. A monopoly is a something in a public domain that government takes from public and gives to the specific person. But invention is something that did not exist before and was not in public domain. Therefore, patent system enriches public domain with the knowledge of the invention. As per the patent legislation, patent is a personal property like any other tangible property and is created by inventor by investing their skills, knowledge, capital, labor, and other resources. And the patent does not grant any positive right to make, use, and sell the patented invention, but is a negative right to prevent other from making, using, and selling such an invention. So these are some supporting views to the patent system. The patent right or property is restricted in terms of scope and duration and cannot be considered as a monopoly. The patent rights leaves many non-patentable beneficial alternatives to the public, that is prior art alternatives, obvious alternatives, and alternatives for improving inventions. The patents intensify competitions. They lead to many improvement. Patent as competitors are motivated to design around. So what are the benefits to the public for a patent system? It motivates to research and invention, provides incentive to the inventor to disclose his invention to the general public instead of keeping it in a trade secret or in a mind confidentially. Commercial reward for the converting inventive ideas into vendable useful products, provides incentive to invest capital to develop new products. So these are some Indian Patent Act development since 1911 to 2005. So what are the patentable subject matter? So what is the patent? An invention means a new product or a process involving an inventive step and capable of industrial application, means it should having 3 criteria. First one is a new product or a process. Second one is an inventive step, and third one is a capable of industrial application. So there are 3 criteria for getting the patent. And what do you mean by inventive step? Inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge. So it should having some technical advancement as compared to the existing knowledge, or having economic significance, or both. Both means technical advancement and economic significance. That makes the invention not obvious to a person skilled in the art. So this is the main criteria, that novelty, inventive step, and industrial application. And what do you mean by inventive step? Inventive step means the technical advancement as compared to the existing knowledge or having economic significance or both. It can be having both features. And what do you mean by new invention? New invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of the filing of patent application with complete specification. So that is the subject matter has not fallen in the public domain or that it does not form part of the state of the art. So got my point? The new invention means which should not anticipated, which has not been anticipated by publication or in any document in the country or elsewhere in the world. And what do you mean by industrial applicability? Industrial applicability means it is defined in the section 21A of the capable of industrial application in relation to an invention, which means that the invention is capable of being made or used in an industry like economics, it should having some economic significance. So sometime you may call that my invention is a novel, my invention having inventive step and having commercial viability also. But as per the section 3 of the Indian Patent Act, sometime your patent may not be patented because an invention which is frivolous or which claims anything obviously contrary to well-established natural laws means if any invention which is frivolous or which claims anything obviously contrary to well-established natural laws are not patentable subject matter. An invention, the primary or intended use or commercial exploitation of which could be contrary public order or morality or which causes serious prejudice to human, animal or plant life or health or to the environment means the invention which is contrary to morality or public order or the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of a new living. So you can see there is a difference between discovery and invention. Means discovery means which is already occurring in nature and which was discovered by someone. But for an invention, it is not already existed in the public domain. So the mere discovery, it is a very important section for a pharmaceutical students or pharma persons for the mere discovery of a new form of a substance which does not result in the enhancement of a known efficacy of that substance or the mere discovery of a new property or new use of a known process, machine or apparatus unless such known process result in a new product or employs at least one new reactant. Means a mere new form of a known compound or a mere new use of a known compound is not patentable subject matter. Like salts, esters, ethers, polymorphs, metabolites, pure from particle size, isomers, mixtures of isomers. So if it is having some efficacy data, so you can get the patent over it. A substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substances. The mere arrangement or rearrangement or a duplication of known device are not patentable subject matter. A method of agriculture or horticulture, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals means a method of diagnostic, a method of medicinal, a method of treatment are not patentable subject matter in the India. So plants and animal in the whole or any part thereof, other than microorganisms, but including seeds, varieties, and species, a mathematical or business method or a computer program per se, or algorithm are also not patentable subject matter. A literary, dramatic, musical, or artistic work, or any other aesthetic creations whatsoever, including cinematographic work and television production, a mere scheme or rule or method of performing mental act or method of playing game, a presentation of information, topography of an integrated circuit, an invention which is traditional knowledge or which is an aggregation or duplication of a known properties. Traditional means it's like a dadi maa ke nuske. So these are not patentable subject matter. Who can file the patent application? So the application may be made by the first inventor either alone or jointly with another or their assignee, legal representative of deceased inventor or assignee. So who can file the patent application? True or first inventor or their assignee. Type of patent applications: ordinary applications, convention applications, PCT international applications, PCT national affairs applications, application for patent of additions, divisional applications, or patent of additions. So these are the contents of the patent application. When you draft the patent application, these contents should be there in your patent specification, like title of the invention, field of the invention, background of the invention, summary of the invention, detailed description, claims, drawings, and abstract. What is the statutory fees for filing patent application? For natural person, it is 1,600, 1,600 for startups and education institution also. For other than natural person startup or education institution, it is 8,000 rupees. And for each sheet of specification in addition to 30, after 30 sheets, 160 rupees per sheet. And for each claim in addition, it is 320 rupees. How to file the patent application? You can file the patent application through online mode or through post, or can be submitted by hand. General procedure for obtaining a patent. So these are some important aspects for getting the patent. Filing of patent application. First of all, if you file the patent application, the patent office will issue the application number and the date that this is your patent application number. And after filing the application, after 18 months, the patent office will publish your application in their gazette notification in their journal that this application has been filed, but the publication will be done after 18 months from the date of filing. If you file the request for early publication, so your application can be published within a month, and the 18 months period will be waived off. Pre-grant opposition, representation by any person if somebody have any objection that this patent should not be granted, so he can file the pre-grant opposition. And the next step is request for examination. If you want to proceed your patent application further, you have to file the request for examination within 48 months from the date of filing. If you don't file the request for examination, your application will be lapsed. And examination done after the request for examination, the patent office will issue the examination report whether which are the objections in your invention, and you have to comply all the objections within 6 months from the date of examination report. If you don't comply the examination report, your patent will be lapsed. And after getting the response to examination report, patent office will review your response to examination report and will, if any objection is persistent, so the hearing may be to the grant, Otherwise, this patent will be granted. And after the grant, your patent application, your patent will be repeatedly again published in the patent journal that this patent has been granted. If any person has any affected person that this patent has not been wrongly granted, so they can file the post grant opposition, but it should having some person interested, means in the same domain. And after the seeing all the oppositions and the decision by the controller. So these are the documents required for filing of a patent application: covering letter, application for grant of patent in Form 1, Form 2 is a like complete or provisional, statement in undertaking Form 3, power of attorney Form 26, declaration of inventorship, certified true copies or requisite statutory fees. So specifications. So there may be two type of specification. One is provisional specification. If you if you file the provisional specification, if you remain some work to finalize your invention, so you can file the provisional specification to protect the priority date. If you file the provisional specification, you have to file the complete specification after within 12 months from the date of provisional, but no patent is granted on the basis of the provisional specification. So in the provisional specification, this content should be there. It should describe the nature of invention and contain the description of essential features. Claims and abstract are not a part of a provisional specification. Fees same for a complete specification or a provisional. But if you paid the fees at the time of provisional, so it will not have to pay additional fee at the time of complete. Complete specification must be filed within 12 months. So important aspects. So I have already told you the publication, examination, pre-grant oppositions, post-grant oppositions, revocation of patents, compulsory licensing. So what is the publication? The period of which an application for patent shall not ordinarily be open to public for 18 months. So your application will be confidential till the 18 month, and after the 18 month, this application will be published in the Gazette notification, provided that the period within which the controller shall publish the application in the journal shall ordinarily be 1 month. If you file the request for early publication, the patent office will publish your application in 1 month. Particulars of publications: number of applications, date of filing of application, title of the invention, publication date, international patent classification, name and address of the applicant, name of the inventors, priority details like document number, date and country, PCT application number. So these are the particulars of the publication. So what is the examination of application? After getting the request for examination, no application for a patent shall be examined. If you don't file the request for examination, your patent application will be lapsed. So it is a mandatory step. Patent office will not examine automatically suo motu if you don't file the request for examination. After the getting request for examination, patent office will examine your application formally or technically on the both part that your application should be granted or not. If there are some objection, they will issue the examination report. And next is pre-grant opposition. Pre-grant opposition means after the publication, where an application for a patent has been published, but a patent has not been granted. So any person may in writing represent by way of opposition to the controller against the grant of patent on the ground wrongfully obtaining, prior publication, prior claiming in India, prior public knowledge, obviousness, not an invention or the invention not patentable, insufficient description, failure to disclose, convention application not filed within the prescribed time, incorrect mention to source, geographical origin, or invention anticipated with regard to the traditional knowledge. So what is the post-grant opposition? At any time after the grant of patent, but before the expiry of a period of 1 year from the date of publication of the grant of patent, any person interested may give notice of opposition to the controller in the prescribed manner on any of the following grounds. So these are the some following grounds. These are some grounds for post-grant oppositions: wrongfully obtaining, prior publication, prior claiming. So these are the grounds which are more or less same as per the pre-grant opposition. Next is revocation of the patent. A patent, whether granted before or after the commencement of this act, may be revoked on a petition on any person interested of the central government by the appellate board or any counterclaim in a suit for infringement that the invention claim is the subject of a patent already granted in India. So these are some grounds for revocation of the patent. Subject of a claim is not an invention. Invention is lacking is novelty. Invention is not useful. The comprehensive does not sufficiently and fairly describe the invention. Claims are not clearly and sufficiently defined. Patent was obtained by false suggestions and presentations. So these are some grounds for revocation. Subject matter of claim is not patentable invention. Claimed invention was secretly used before the priority date. Failure to disclose information regarding foreign application, non-compliance of secrecy action, leave to amendment of specification obtained by fraud, specification wrongly mentioning or not disclosing geographical origin, inventions is anticipated by traditional knowledge. Section 84, complete compulsory licenses means at any time after the expiration of 3 years from the date of the grant of a patent, any person interested may make an application to the controller for a grant for compulsory license. So on the grounds, the reasonable requirement of the public with respect to the patent invention have not been satisfied. Means reasonable requirement have not been satisfied. The patent invention is not available to the public, or the patented invention is not worked in the territory of India. So this is very famous case. I would like to quote famous case law regarding the pharma community. India's first ever compulsory license was granted by the Patent Office on March 9, 2012 to Natco Pharma for the generic production of Bayer's Corporation's Nexavar. Nexavar is a life-saving medicine used for treating liver and kidney cancers. And Bayer sold this drug at exorbitant rates, around 2.8 lakh per month. And Natco Pharma offered to sell it around for 9,000 rupees for a month, making it affordable for people belonging to every stratum. All the three conditions of Section 84 have been met, and the compulsory licensing has been granted to the Natco Pharma. After the granting, the patentee should have to pay the renewal fees every year or till the 20 years from the date of filing. To keep a patent in force, the renewal fees shall be payable at the expiration of the second year from the date of the patent or of any succeeding year, and the same shall be remitted to the patent office before the expiration of the second or the succeeding year. While paying the renewal fee, the number and date of the patent concerned and the year in the respect of which the fees were paid shall be quoted. The annual renewal fee payable in respect of 2 or more years can be paid in advance. Even you can pay the advance fee till the 20 years in a single time. So this is the renewal fee structure. Up to 6 years means first 2 years there is no renewal fees. From upward onwards to third year to 6th year, it is 800 per year for a natural startup and educational institutions, and 4,000 a year for other than natural startups and educational institutions, and 7 to 10 years, 2,400 per year, and 12,000 per year for others. 11 to 15 years, 4,080 year per hours per year for natural startups and educational institutions, and 24,000 per year for others. 16 to 20 years, the rupee 8,000 per year, and for education institutions, startups and individuals, and 40,000 per year for others. So sometime you may call this is the patent searching for the very tough task. If you see this diagram, you can see this is the spring. But in the patenting term, it may called energy storing means. Yes, this type of jargon oftenly used. You can see there is a transistor, but in the patent jargon, a semiconductor switching device with a control electrode. It is simply toy ball, but in a patent term, it may call spherical object with a floppy filament. So these are some examples which got the patent in ancient age, like the CATSEYE, traffic signals. Nowadays these inventions looks very obvious, but at the time of invention, these inventions are really game changers. The radio, camera and stumps. Yes, you can see there is a camera is already available and stump is already available. But if you have embedded the camera in the stump, so there will be more beneficial for the cricket community. And a paper clip. If you see this paper clip, if you unfold this paper clip, so it's a simple piece of wire, nothing else. But it has very good utility for a paper grasping. Alarm clock, sewing machines, camera, paper clips, alarm clocks, sewing machines, refrigerator, clocks, guns and pistols. Yes, you can see cooker, pressure cookers. These are some pressure cookers which seems like autoclave, na? And refrigerators, typewriters. Some inventions already outdated nowadays. Vacuum cleaners, washing machines. So this is the type of patent certificate. So what are the recent trends in IPR? National IPR policy was launched in 2006. Make in India project was also launched to uphold the innovations and Startup India. Digital India was also launched. Skill India campaign. Stand Up India, Adult Tinkering Labs established in the school level, and National Innovations and Startup Policy was launched. So these are some recent trends. And if you talk about the recent trends, recently in the year of 2022, around 65% patent filing related to the Indian applicant, and only 35% filing are related to the foreign nationals. So these are some very drastic changes nowadays. You can see the recent trends. Thank you. Thank you, Dr. Pawan.
Thank you, sir. So thank you for your valuable session, sir. So any questions from the participants? You can ask the sir, or just you can post the message.
Please.
Yes, sir. There is also mail ID in the slide. You can also share your any queries or doubts with the respected speaker, sir. Okay, then, sir. Okay, sir. Then, so we can conclude, sir.
Okay, sir.
Sir. Okay, on the behalf of management of Chebrul Hanuman Institute of Pharmaceutical Sciences, on behalf of principal, sir, staff and students, so we thank you, sir, for sharing your valuable information and knowledge regarding this Indian patent system, patent processing, and what type of things can be patented, what cannot be. So thank you, sir. Thank you very much, sir, for being as a guest speaker for this impact lecture series. co-sponsored by Ministry of Education, AICT, and Institution Innovation Council. Thank you, sir. And we will hope for your cooperation and sharing your knowledge in future also, sir.
Thank you, sir. So
Thank you,
nice.
sir. Yes, sir. Thank you, sir. Thank you very much, sir.